During the month or so before this seminar, the local and national news media carried stories about a federal judge finding the state of California tortured prisoners, including by spraying inmates in the face with pepper spray multiple times just to administer their antipsychotic medication. See Coleman versus Governor of California, Department of Corrections and Rehabilitation, a 24-year-old case as of 2014. In New York, at Rikers Island, there were verified reports of jail guards handcuffing juvenile inmates out of the sight of cameras and severely physically abusing them. California was found to be violating the constitutional rights of prisoners by cruel and unusual punishment in violation of the Eighth Amendment. See Coleman. Accordingly, the San Francisco Sheriff's Department reneged on being a panel speaker, stating that they also used pepper spray. Dr. John Doucet, a psychiatrist who had been on contract with the California Department of Corrections and Rehabilitation for approximately 20 years, agreed to be a speaker, but did not show up or call to cancel. Notwithstanding the above, PWDF proceeded to have a public discussion on these important prisoner issues.
Tom, one thing I've wondered about having worked in this and the Social Security system, and that is triage, which means assessment and intake. And I am aware that CDCR has hired people for the major, what they call screening unit in Northern California, at least at one point in time, of San Quentin, and another primary one in Southern California. But I wonder, I did read again in the orders on your case, the Coleman case, it mentions that the clinicians don't really have the charts with them when they're doing consultations. And we get, when I say we, as a Social Security practitioner, dual diagnosis, and we get diagnoses where we have people who have, from looking at their rap sheet alone, you can see there's a very aggressive assault history, maybe attempted murder on some people, and robberies, and people who are always in combative situations. But then you see someone with severe cognitive and developmental disabilities. Maybe their reading level is 4th or 5th grade, and other neuropsych testing could reveal that they have major deficits in different kinds of analysis, and especially our clients with autism. And so whether it's autism or intellectual disability in combination with mania, as in bipolar, or schizophrenia when someone is in an active psychotic episode, I wonder, because of the nature of CDCR being a large bureaucracy, if there's evidence that you've come across, not that you've personally seen necessarily, where there's really a trade-off. In other words, why not give the person antipsychotic medication, turn them into a zombie, and you don't have to spend all that staff time explaining instructions and things, so they really understand. In other words, what we've heard, at least in part from the Coleman case, is that some of these people really are being punished for not following directions, and they don't really understand them, and it would take a lot more time, to explain, to accommodate someone, as you would have to do in certain ADA cases. Reasonable accommodation to take the time to explain at whatever reading or verbal comprehension level they're at, instead of electing to give them a higher dose of psychotropic medications for whether it's mania or certain psychoses that will treat one of several diagnoses. Could you comment on that?
Sure. So, there's there's different systems have developed through different lawsuits for screening for and tracking people with mental illness and with developmental disabilities. So, developmental disabilities are covered by a lawsuit filed by the Prison Law Office called Clark, and in Clark, they got an order that all prisoners in the CDCR get given a pretty rudimentary screening for developmental disabilities, and that it's focused on sort of adaptive functioning. So it's designed to be a screening that's relatively inexpensive to deliver to thousands of people, and that when you get a positive hit, from what I understand, it's designed to kind of give very detailed instructions about what kinds of prompting somebody might need and what kinds of protection somebody might need. And so in Clark, there's DD1, DD2, and DD3, depending on the severity of the developmental disability. And DD3 is the most severe, and you'd be in a sheltered living unit with very intense staffing. And, I've never sat and compared it to probably the equivalent mental health program is something like the EOP program. And in terms of staffing and management, I think you're probably right. I think it's probably the case that the developmentally disabled demand more services, although the clinical services are probably more expensive for the mentally ill in terms of psychologists and psychiatrists and therapy time. So, but the way people get screened is they come into one of, I think there's now 6 reception centers around the state, and that's where you go first before, there's 34 prisons, but when you come in from a county jail to serve a state prison sentence, you would go to one of these 6 reception centers. And in the mid-90s, there was an issue that people with disabilities were spending too much time in those reception centers where they couldn't get jobs, and they spent a lot of time locked in their cells, and so typically it used to take about 60 days to process people and to screen them, but all of these cases have actually added to that time. So I think now it takes more typically 90 days or something. But they do what's called a bus screen, where when you get off the bus from county jail, they do like a 15-question questionnaire, and a nurse sits down with everybody coming off the bus and finds out if they have physical disabilities, if they're suicidal, if they're on psych medications. And when it works, it's pretty good. And there's some flags on that would lead to further psychiatric screening within about 24 hours. And I think that the mental health screening is pretty good just because it yields such large numbers. But there's a team of experts who have monitored that, and I think have been fairly favorably impressed with that. I do know a little bit more about I don't know that much because I don't work on Clark, about the DD screening, but I do know that some of the death penalty lawyers don't think that screening is very good. So, of course, developmental disabilities and particularly intellectual functioning is because the Supreme Court has said you may not execute somebody who's mentally retarded. That's become a very important component of death penalty litigation. So naturally, they would want that assessment to be done very carefully. But in terms of just practical functioning, I do think you're right to identify there's a problem with the overlap between the two, and people who are dual diagnosed often get assigned to one or the other. You often hear staff say, that his mental health needs predominate or his developmental disability needs predominate, and they really all need services for both conditions.
I know I've had a lot of clients for applying for SSI who were either about to get out or just getting out of state prison. I remember one guy who, and this was a state-employed psychiatrist who had the diagnosis bipolar, homicidal, suicidal. And I had never seen a diagnosis so strongly written. And what they did while he was in the facility at Corcoran was kept him for a lot of time in the SHU, and that's when I first started hearing about a sensory deprivation kind of discipline. But it also occurs to me that that's just from an administrative ease point of view, a way of avoiding further assessments and trial and error with medications, and then you have to titrate up and down the medications. I mean, now we're talking about bipolar, but is that something where it's people have looked into? Again, I guess I'm still talking about administrative ease of the state agency, the CDCR. I mean, besides loading them up with pills, I mean, keeping them in the SHU, sensory deprived, which is maybe overused and abused, is certainly one way from the state's point of view of keeping things within their budget and so forth.
Yeah, I don't know how much it's budget driven, because it's I think it's driven by, I think that the custody concerns in the prison system predominate. So the guards union is very powerful. The sort of law and order state legislatures are very powerful. So the sort of drive to impose new and varied security restrictions over the years has been very well funded. So, building those SHU units actually is tremendously expensive. They're probably twice as expensive as a regular cell. And they're also much more expensive for mental health care, because in the Coleman case, we have required, when you lock people down, you need to provide more services. So when the mentally ill people are in the SHU, they have to get 10 hours a week, and that's costly. It requires escort staff. It requires... So in terms of administrative convenience, I'm not sure that that's an issue. There is certainly some... there certainly have occasionally been, some of the court experts have been concerned about over-medication, but that also has not been the primary concern. The primary concern is more often somebody who's quietly psychotic or missed, because when you're in a SHU unit, your level of functioning is hard to measure, because you don't have to do much to function. To be gravely disabled, you'd have to not accept the food passed through the food port to you. There's a lot of things in the free world where you're going to pick up somebody who's gravely disabled or a danger to themselves, where when they're locked 23 hours a day in their cell, you may not be able to recognize that as easily. So the risk has more to do with people not recognizing that somebody has a more severe psychiatric condition and moving them to a state hospital or to a crisis unit or to give them involuntary medication than it does with over-medication in those units.
Is it much of a problem when they are doing that initial screening or off the bus screening, as you describe it? And let's say they are ordering charts, like here in the Bay Area, we have places like John George, which is part of Alameda County. It's the mental hospital, or Langley Porter in San Francisco. And sometimes you order charts and they don't come, or they may come, but not for several weeks. Or when you call the records department, it may be 2 months. And to what extent, if you know, and I assume things like this probably are frequent, that is looking at a history of someone who may whether or not they have multiple diagnoses, it would be very telling, really, to look at their medical charts, the histories, because as you said, 28% have severe mental illness, and certainly the chances are more likely than not that they have been in the state or county civilian 50, whether they're 5150 as they call it in California, or Baker Acted as we call it in Florida. Those charts are so important in doing a correct assessment. I wonder if what happens.
Yeah, so that's a big problem. So they have trouble getting their own charts. So if somebody goes out on parole and then they come back in to get their old paper charts, can take, much too long. So a new clinician doesn't have the benefit of the prior diagnoses or the prior history. And then it's also the case, they are now moving to an electronic system, which hopefully will solve some of that. But historically, there have been terrible problems just getting their own CDCR records from prior terms. And then they often will not order or will not get the full record from, say, the Department of State Hospitals. Often people will come in and they've been through an IST process. And so as a result of that, they've gotten a really good workup at a state hospital that has a, great history, and, and they've tried a couple different medications. It may be somebody so we had a guy when we were going out to San Quentin that we met with, who also actually was one of the videos of, just happened to be one of the videos of a person who being cell extracted. But Pablo Stewart, our expert, and I went out to San Quentin last January in 2013, and we met this guy, and he was very psychotic, very paranoid, and he was in a segregation unit, and we were, kind of questioning, why is he here? He seems far too mentally ill to be here. And when we finally got his records, he'd come in, and he had been just a few months earlier at Napa in an IST program, and he'd done very well. And he was bipolar, and when he was on medication, he did much better, right? He was a totally different, presented very differently, and they actually cell extracted him without having the Napa records. And a doctor, after this horrific cell extraction, they bring him up to the mental health crisis bed, and the doctor says, "Oh, he's not seriously mentally disordered. He's just got a personality disorder. I've seen this angry type before." And he sends him back to that same segregation unit, unmedicated. And that was really it. And then 10 days later, they finally get the Napa records. And even once they got the records from Napa, it wasn't clear that anyone looked at it and said, "Oh, this makes it clear that he has a long history of bipolar disorder and some manic phases, and he does well on medications, and in particular on this medication." They never made use of that. So maybe another 3 cell extractions later, they finally read that document and understood what it meant.
Is there some legal standard for the due diligence they should be using in doing that, the screening and I guess continuing assessment, just like in the example you said, where maybe one particular bipolar medication did work, which is not at all uncommon. People have terrible side effects to Lamictal and end up back on lithium because it worked the best, having already been through trials of different medication. Or is the due diligence standard as long as they make some attempt, request a chart? And
I don't even know if they have to. So I have not seen, I don't know the case law in that area, but I have not seen them get into legal trouble around this particular issue. It hasn't been an area of focus. And my sense is that HIPAA has actually given a little bit of a shield to the state, that DSH, people overread what cannot be shared with other clinicians under HIPAA. Somebody's psychotic or not cooperative, so they're not going to sign a waiver for you to send to DSH, the Department of State Hospitals. It can be tough for the Department of Corrections to get those records. So even though they have a working relationship where if somebody goes from the CDCR for treatment at DSH, they get they'll get a very good discharge summary, and they'll get some pretty good detailed records. But yeah, that's a big problem.
It seems so easy to get a wrong assessment. Recently, I had a guy who worked for the U.S. Postal Service for 5 years, and eventually he got on FERS, which is like CalPERS. It's just the Federal Disability Program. But it was pretty clear with an IQ of between 48 and 56 that particular agency, I mean, they let him stay for about 5 years, but it sort of jaded the whole process. It wasn't CDC, it was Social Security, where there was some kind of a presumption anyone who's been working for 5 years, even if he was just on the rolls and not really working, I mean, someone really needed to, the judge was having a hard time accepting the psychiatric opinion, which was he had the highest degree of severity when it came to intellectual disability, plus some others. I just assume at the CDCR level where maybe, they don't have the chart to begin with. I know, and this is, I don't know where Dr. Jusay is, but when I first met Dr. Jusay at a Social Security hearing, he was, and this was back in '95, he was telling me that he was on an investigatory panel of CDCR, and when they were doing their assessments, they were asking, now, were the pills you were taking, were they the pink ones, the red, or the purple? It was really, and it may sound funny now, but that was really sort of the state of how they were doing the history to determine what treatment, in other words, what medications, even if it was to continue the same ones. It was really that bad. I mean, maybe it is in parts and not in others, but
one thing that has happened in this case is the quality of the treatment records has gotten much better. So like the CDCR has improved documentation of what's going on with somebody and their history. It is still the case that the Department of State Hospitals really, if somebody has a term there, they get a workup that's a little more complete, and they get a concise kind of discharge summary that has a really good, thorough history. It'll have medications that have been tried and that worked better than other medications, and I think it's partly a function of it's very psychiatrist-rich staffing in the state hospitals. So they have a more medical and more medication-focused view, but there have been problems with the quality of treatment records. But I do think the move towards electronic health records is probably hopefully it'll be helpful with these kind of issues.
Well, the VA went through that, and I have to say they are pretty easy to read. I mean, they're all typed out. That has nothing to do with the reflection of the quality of the treatment.
No, but it's more easy to use the records, right?
Right.
Yeah.
It's easy to get them and read them. What work went into them is a totally different story.
And of course, the electronic records, there's a risk of boilerplate that doesn't change, which is problematic, right? Because it's digital, you can just clip and paste the last note. So.
I'm wondering, why is it, and this was in one of the Colin case orders that I was attached to, I guess it is CDCR policy, they are not going to treat someone from withdrawal if it's an addiction case. I mean, the effects of let's say it's psychosis from taking methamphetamine for over 10 years. I think most of us have heard that or possibly cocaine, but not heroin or other opioids, can lead to psychosis. But why is that? Why is that something that's would be, if you know, would be policy? Withdrawal symptoms are physical in large part, and getting very, very sick. I mean, is that just a statement of morals or something because the person was a drug addict? And I mean, there are certain medications to help people through withdrawal, but I read that.
Well, so
somewhere.
I think that there are some prisons that do give medications for helping people through withdrawal, but there is a general attitude which often impacts people with real pain management issues, where they will discharge somebody from, for, say somebody's getting what's the drug that you get when you're going off heroin is methadone. So if people are on methadone for pain, they'll often come in and they'll discharge them from that. And I've never understood that. And there's some idea like, oh, we need to get you clean, and then we'll start from that baseline or something. But I do know some of the like anti-nausea drugs and stuff like that are used for somebody in withdrawal. I think they are given sometimes. But there are sort of strange issues about treating. Obviously, people in withdrawal from methamphetamine, it's dangerous not to treat them. So.
Same thing, I guess, with the benzodiazepines like Valium. A person could have seizures if they aren't, tapered off.
Right.
But
I mean, there's also just a fear of contraband in a prison environment. Mm-hmm. So again, it's one of those places where the custody mentality comes in and interferes some with the treatment.
Because I think it was really on the list, I don't know if it's the one we talked about earlier today, where there was a list of bipolar 1, 2, schizophrenia, that plus medical necessity plus something else, but it specifically excluded and said excluding effects of withdrawal from drugs. So it's probably some combination of not having drugs. Well, they would come from the pharmacy or creating addicts or some.
Right. I mean, I think it's just hostile. I mean, I think it reflects some hostility towards addicts and addiction. Like I think that it's in the ADA. Isn't there an exclusion for addiction as being a disability?
Well, the exclusion is if it's a current active addiction, you do not get the protections under the ADA, but a history of you do.
But you get kind of the regarded as.
The regarded as, correct. Regarded as or history of, you are protected under the ADA, and certainly that would apply to the prisons. Title II ADA, Title II is the state and other governmental entities. So I think that came up in a case, I don't know which circuit, may have been the Ninth Circuit, where people who were former drug addicts were less likely to be paroled the same as people who were not former drug addicts. And the Ninth Circuit found discrimination. I mean, it is really explicit in the ADA, regarded as or history of,
right.
is protected as opposed to currently an active addiction. I mean, that's where Congress drew the line for that particular statute. So maybe that's part of the reason. I mean, from a legal analysis point of view, if someone needs withdrawal medications to lessen the psychological pain, and psychological pain is mentioned in the Coleman case as one of the injuries, because if they're withdrawing, they would be more active. And I know in addiction, there's a lot of disagreement when you ask how long since you were an active addict before you're covered in employment or for any other reason. And I know some people used to say a year, some 6 months, because it comes up in employment in other areas. And I always, when I spoke on this, I used to say 2 months, because certainly by the end, or 45 days, because the same question comes up, how long do you have to wait before you administer psychometric testing to get an objective baseline for it? And it's really not totally settled. Different people just seem to have different ideas on where that line is drawn. Of course, it makes a big difference in getting protections of the anti-discrimination laws. Yes, Steve.
Hi. Can you talk about the enforcement of the orders in Coleman and whether you've witnessed or experienced any kind of resistance in complying with those orders?
Oh yeah, I mean, it's been going. The case has been going on for 24 years, so there's been a fair amount of resistance. I mean, some of it is the special master in the first part of the case. Michael Keating, I think, felt that there had been a lot of progress, and then overcrowding overwhelmed it. So, but there's different kinds of resistance from the prison system. They're not used to outsiders coming in. They've gotten more used to it over the years in California because they've been repeatedly sued successfully. I mean, the prison law office has brought, with outside counsel, probably 13 or 15, 16 class action cases, all of which have won, and which have brought various parts of the prison system under control. So the prison system's gotten used to us, but the there's always resistance. People want to run their own system. The governor filed to terminate in January of 2013 to try to get out from under the court supervision in Coleman, and he lost. But there's periodically been stronger and weaker resistance. The special master, I think, has struggled with how to cajole and get sort of investment and cooperation from the Department of Corrections to make the changes needed. It's such a big, complicated system. There's a kind of trained incapacity. Judge Henderson talked about trained incapacity when he ordered a receiver for medical care in Plata. Administrators are used to not being able to get things fixed in the Department of Corrections. I mean, some of it is also the role of the guards union. I mean, the correctional officer posts are 70% post and bid, which means 70% of all jobs are determined by seniority. So the administrators, the warden, and the healthcare administrators can only have control over 30% of the positions. So you might have a group of 4 or 5 officers who are great with the mentally ill or great with developmentally disabled individuals, and you may not be able to keep them all in those units because somebody with more seniority wants that job because it's good hours. So yeah, there's resistance, and it's also I think a big factor is also just that we're not there 24 hours a day. We go out and see our clients. We always call in advance. They know we're coming. We can't be there all the time to protect our clients. So there's a fair amount of retaliation. People who come forward and the prisoners who come forward to tell us what's going on, I think, risk some serious consequences. It's almost like there's some resistance just built into the fact that they're prisons. You have to get a court order to go in and walk around them, and then you have to get a gate clearance and a security clearance, and you're escorted everywhere you go. And I think we probably have better access than prisoners anywhere else in the country. So, I mean, prisoner lawyers. Did I say prisoners? But I don't know. There's also like one of the things that makes the cases like this slow is you just don't have perfect knowledge. Some stuff takes us by surprise. I mean, we were in a meeting once, and somebody sort of slipped up that they were doing video monitoring of suicidal prisoners, and we had no idea it was going on, even though we communicate with hundreds of class members, and the experts in the case were said, if you use this video monitoring, you're going to have video of people taking their own lives, because it's one-to-one monitoring is really critical, and they did have video of people taking their own lives a couple months later and stopped it. But or we were wondering in the suicide prevention area why so often the custody officers weren't doing CPR. We said, what and somebody we didn't even occur to us. Somebody said they're not required to. They're required to do it for fellow officers, but they are required to do it now. But they were not at the time. They were not required. And that was just, our jaws fell open. We assumed that they were required and we're going to do CPR, but so it's more stuff like that.
Has it been difficult to gather information about the conditions in those prisons from the prisoners who might have severe impairments and an inability to communicate what's happening? Not really. I think so. It's such a large class. It's 36,000 prisoners are Coleman class members, and they're all at different levels. And so there often are prisoners who are pretty high functioning, who can tell us their own story, and will also tell us what's going on with other people. I think when we were doing the overcrowding trial, starting in 2007 and touring prisons, for complicated reasons, the guards union felt, I think, that the prisons had become pretty unsafe, and so they were on our side in the overcrowding trials. And it's interesting. They knew what was going on from their members, and we knew what was going on in a lot of prisons from our clients. And the administrators and the sort of state structure had a much less good idea of what was going on.
Hello.
Hi.
From what you're saying, that the prison is very resistant to change, and obviously they don't have any self-monitoring system as far as abuse of the prisoner or the mentally handicapped prisoners. I was just wondering if you have, or any of the prisoner attorneys groups have thought about maybe kind of in cooperation with some of the church groups. I know there are church groups, they do a lot of ministering in church, in the prison, and they have regular visit there. Maybe they can be enlisted to help monitoring the abuse of the mentally handicapped prisoners.
We do occasionally have communication with chaplains, and you're right to point that out. That is one exception to the general rule that outsiders don't have good access. Is the chaplains have pretty good access, and often they're very caring, good people who we do. So they will often tell us if somebody's really having a terrible time that they're aware of. But there's a limited group of people who are religious, so that's not a way to reach people who are not, or find out about serious problems with people who are not involved with the church. And then the chaplains have their own political barriers, right? They are serving at the pleasure of the prison system, so there's a limit to what they can do without suffering some retaliation. So, but we've often heard, about clients in trouble or from chaplains at different places.
Have you ever filed reprisal complaints, or is that something which
You know, we did in the Gates case, we filed a retaliation, and you know that was a case where we had a pretty sympathetic mediator who it was tried in front of, and they're hard to win. The law is not that great. I think that the legal standard is that you know, you kind of have to show a retaliatory intent, right? And you don't, you know, it's not like you're going to have access to emails or sort of open-ended discovery. And the standard is something like if the thing about prison is there's so many administrative things that can happen to a prisoner that are seemingly neutral. You know, for most prisoners, once you've kind of got a set job and a set housing unit and you're at the same prison, you may have figured out a way to be safe, you know, where you don't have to risk assault or sexual assault, or you kind of figured out the politics and you just want to lay low. And so, you know, just moving somebody to another yard or another prison, which you can do for any number of reasons, could be super upsetting. But that kind of retaliation, it's very hard to show that that's intended as punishment for somebody who's speaking up for their own rights or for somebody else's rights. There are a surprisingly number of prisoners who are not fazed by that. I'm pretty admiring. I mean, there's a lot of people who are willing to tell the truth about what's going on in the prison and suffer the consequences. But I think there is a lot of retaliation, and I think the legal standards make it hard to get at that. So.
I was wondering if you could talk a little bit about the order that came out at the end of August that was going to, I guess, set in place some new policies and procedures.
Which kinds do you have it? We've gotten so many orders in the last year. Well, so this is based on, this is sort of a further order about the sort of remedial process involving administrative segregation units. So in April, the judge's order basically set forth a process for developing new special mental health segregation units. So if somebody is actually a triple CMS, if somebody is at the lower level of mental health care, if they're triple CMS, and they go to a segregation unit, they get augmented mental health care, but not that much. They get a case manager meeting every week, and they get more often treatment team meetings, and there's more rounding. But because of the litigation over, we raised a lot of issues about the use of segregation. One is that it's often used for non-disciplinary reasons. People are put there for protective custody, but they're treated as though they're put there for punishment. And then the lengths of stay are terrible. So the judge has basically ordered an ongoing process to create new units with more treatment and to limit the stays of people in segregation units and to separate out the non-disciplinary segregation so that they're not so punitive for somebody who might be coming forward for protective custody reasons. And this is just another order about that. It's going to probably be an ongoing process where the defendants started off in the middle of our evidentiary hearing by revamping some of the rules. And then they've put together this order is kind of basically confirming their plan to create these new mental health segregation units. They have these. We obtained an order in about 2002 banning the use of these newer segregation units for the mentally ill because the cells don't have windows and they're very shoe-like. So we got basically an exclusion order. But the special master staff, I think, felt that those units had a lot of treatment space, so that they, in some ways, would be good places for mental health treatment, in spite of some problems with the actual physical spaces being pretty severe. And so they basically proposed to I think it's 3 hours of treatment and 20 hours of maybe those are not precisely the right numbers, of out-of-cell activity and a certain amount of day room activity. So basically, they'll become much less like typical segregation units, and there'll be a lot of out-of-cell time, and there'll be more mental health treatment, and there'll be some limits on the lengths of stay there too. So because of those trade-offs, I think we're willing to allow it to go forward and see how it goes. So.
Have you seen less sensory deprivation? I mean, during the course of the litigation, some of us think of being thrown in the hole as just that, in a dark place without seeing daylight in windows, except for that, I guess, 1 hour a day, or the
1.5 hours, 1 or 1.5 hours a day.
1.5 hours a day. But over the 20-some years that you've been, involved in the Coleman class cases, have you seen any change in sensory deprivation as a form of disciplinary action?
Well, so there has been change. There was a big change in getting the mentally ill out of Pelican Bay that happened because of the Madrid case, and there was a similar exclusion order. So if you're EOP, they weren't going to send you to the regular Corcoran SHU. They had to send you to this special PSU unit. But because of overcrowding, the overall trend in the prison system, as I described kind of in my talk, became one where there was more and more lockdowns. And that's a kind of mini sensory deprivation. You're just locked in a regular cell, but you don't get out. It's not as bad as the windowless high security SHU units, but it was certainly very widespread for the decade between like 2000 and 2011. There was people are very, very locked down in the CDCR. I do think that there might be, some awareness on the part of clinical staff in particular that it's damaging. But I think the countervailing problem is that once people are in these locked units, they're kind of hidden away. Like I went out to what's actually a healthcare unit at a prison CCI, Tehachapi, 2 months ago, and I was interviewing somebody in the Armstrong case just because he had a mobility impairment, and he was in this healthcare unit where I wanted to make sure he was getting privileges and stuff. And it turned out he was a psychotic Coleman class member, and I just couldn't believe that nobody. I mean, he was one of the saddest people I'd ever met, and he was so. He saw demons in his cell, and he didn't want to go to sleep because he was afraid they would attack him if he fell asleep, and so that was part of why he was not taking his medications. And he was just, looked haunted and tired, and he needed to go to an inpatient hospital program. I mean, he really had a desperate need for mental health care, and I couldn't really understand why none of the clinicians had seen that. And I think it's just somebody's behind a locked door, and people are walking by the front of the cell. It's easy to forget or to not notice how severe their condition is. And he was single-celled, so it wasn't like there was a cellie to yell out, "Hey, you got to get something for him." But he'd been in that way for 6 months. There were notes talking about his psychotic delusions from 6 months earlier, and I was able to get him moved within about a week to CMF, and hopefully they got him into an inpatient program. But yeah, the fact that people can be missed because they're just behind a locked door, and so many people are locked in their cells, is a big problem. If somebody like that is supposed to go out and go to a program and work, or in an education program, staff are going to notice this guy really needs help and get him moved.
Yeah, I guess out of sight, out of mind,
Yeah.
it sort of works that way. Although when you look at the legal factors that contraindicate putting someone in some of these circumstances, increased risk of decompensation is very clearly stated, and it would seem to me that sensory deprivation, when applied to someone who has a degree of fragility in terms of their severe mental illness, would be or should be pretty obvious to the clinicians, whatever experience they really have. I don't think it's rocket science to figure out that someone who's already tried to kill him or herself, multiple times, and have already have decompensated, by history, that that risk should be obvious.
It's funny.
It just seems that way.
It's such a big system, though. I think that we have these cases of people who go to. Take this off. We have these people who go to DSH, and they go and they get inpatient. They get the highest level of hospital care, and they get better. They stay for 6 months, 8 months, and often they'll we call it, discuss the issue as psych and return. So they get returned to the same unit they came from. So they were in segregation, which was toxic for them, and they decompensated. They go to a hospital. You don't want to send it. You should not send them back to these sensory deprivation environments. They've been in a rich treatment environment where they're out of their cell a lot, and they're programming, and there's lots of rec therapy, and there's lots of therapy groups, substantive groups, and they go back and they get locked in a cell again where they will decompensate, often quite quickly. So some of it is that the people who should know and be concerned about continuity of care don't have the power to get somebody moved. It's a custody decision often, and then some of it is that it's a big system. So the clinical caregiver, when they come back to the same prison, might be a different yard and a different doctor. They might have a different psychologist and a different psychiatrist. So, there's 34 prisons and 35,000 mentally ill. So it's a big system.
So in other words, having the policy which says these are the factors, but not following it is sort of what we're talking about, because clearly that is in writing at this point. It is, if it will increase a substantial risk of decompensation, is a reason not to do it. But that's just the way it is, and a combination of reasons, as you said, in a state bureaucracy. It could be any one of those reasons.
Yeah, I think it's just another one of the ways that being mentally ill and being in prison are not very compatible. It's just, again, it's partly the security stuff trumping the need for compassionate mental health care.
It's public opinion generally on the side of the state. In other words, people or the state's prison argument could certainly be, these people, do you know why they're in there? The scum of the earth, and they've attempted murder on a mother and her baby and stabbed so-and-so 42 times and tried to kill her 3 kids, even though we may stop and think that person, didn't know what he or she was doing due to severe mental illness, because that's what we're talking about. Is there a public pressure?
There definitely has been, and definitely, there's been, in California in particular, there's been a kind of crime victims lobby that's been very powerful. The guards union has been very powerful. The sort of law and order district attorneys, particularly from Southern California, have a lot of influence. And I think, some Democratic Party leaders, most, I think, distressingly, decided that having the support of those law and order people made them look tough on crime and kind of manly in a way that they that was, expedient for them. And so I think that, in the last 30 years, California has had, terrible prisons and terrible prison overcrowding. I do think that's beginning to change. Prop 36 passed in 2012 to reform some of the worst parts of our three strikes law, and then we just passed Prop 47, which also will keep some people convicted of very minor crimes out of prison. So those are both favorable. And I think there is finally a national debate questioning our policies of mass incarceration. I mean, the U.S., in one of the slides I had the U.S. Rate per 100,000 in prison, it's about 758, I think. And the rate for African Americans, I think, is for African American men is 4,600. I mean, it's an unbelievable rate per 100,000 in prison, and those compared to rates in Europe, like in Germany, the rate is 90 per 100,000. So if you're an African American, I calculated at one point, if you're an African American in California, you're 55 times more likely to be in prison than an ordinary German citizen. And so, I think that the expense of the criminal justice system has been a big factor in turning people against mass incarceration. And I think some of the racism, I think the cocaine laws, the disproportionate sentencing for crack cocaine, which clearly I think everybody agrees, even some very conservative people agree was racist. I think that has all turned the tide a little bit against our sort of mass incarceration policies and our sort of the public's knee-jerk desire to be punitive with respect to criminal justice policies.
Okay, I think is there any more questions in the audience? Okay. Thank you all for coming to our seminar. We hope it was educational and meaning to you all here. If you have any questions or comments on today's seminar, please contact People with Disabilities Foundation. Our phone number is 415-931-3070, or you can email us at info@pwdf.org. The seminar is now closed. Thank you.
Thank you. Thank you. Thank you. That's good.